in the sense that the remedy of a no confidence motion would be available to any segment of the legislature seeking to espouse the view that the government has ceased to command the confidence of the House. In exercising the constitutional authority to demand a trust vote, the governor must do so with circumspection in a manner that ensures the authority of the House to determine the existence or loss of confidence in the government is not undermined. Absent exigent and compelling circumstances, there is no reason for the governor to prevent ordinary legislative process of a no confidence motion from running its due course. The governor is an appointee of the president but does not represent either a political ideology or a political view. The governor is expected to discharge the role of a constitutional statesman. The authority of the governor is not one to be exercised in aid of political dispensation, which considers an elected government of the day to be political opponent. The precise reason underlying the entrustment of the authority to the governor is the ability to stand above political conflicts and with the experience of statesmanship to wield the authority in a manner which subserves and does not detract from the strength and resilience of democratically elected legislatures and the governments in the states who are accountable to them. To act contrary to this mandate would result in the realization of the worst fears of the constitutional framers, who are cognizant that the office of the governor could potentially derail democratically elected governments, but nonetheless place trust in future generations to ensure that the government of the people, by the people, and for the people would not be denuded by those who are designed to act as its sentinels.
There are 74 also. First 4 lines.
In discharging this crucial role, it is necessary that the governor bear in mind that the purpose underlying the entrustment of the authority to require a trust vote is not to displace duly elected governments, but to intervene with caution when the circumstances which are drawn to the attention of the governor indicate a loss of majority. And that is exactly what the governor did in this case. 7 independent MLAs write to him to say we are withdrawing support. The leader of the opposition writes, 34 of the 55 MLAs, now of course 40, say that within the party, that's why I know this whole thing of split, merger, that's never our case, that's their case. To say that since there is no merger, since clause para 3 is not available, you have per se incurred the disqualification. And our case right through has been that whether we represent the political party, the Shiv Sena is the recognized political party, or you do, is a matter which the Election Commission will decide. The Speaker, my lords, if your lordships will recollect, and just
equally in the present case, when the leader of the opposition writes to the governor could have advised the leader of the opposition, bring a motion of no confidence to the House.
Right, but my lords, nothing stops the governor. Today, we are testing the bona fides of a decision. My lords, to say that the governor opted for one option instead of the
opposition cannot duck the responsibility of summoning or placing a motion of no confidence by getting the governor to direct the convening of a trust.
My lords, may I with respect say the leader of the opposition did not get the governor to do anything. The leader of the opposition brought it to the notice of the governor. 7 independent MLAs also brought it to the notice of the governor. 34 MLAs within the party wrote to the governor to say that we will not support this ministry. And the governor, in exercise of his discretion, after applying his mind, satisfying himself that the conditions accepted, followed Bumai, followed Shivraj Singh Chauhan to say that the best course of action available would be a floor test. If your lordships in a 9 judges and Shivraj Singh Chauhan have said that that is the first course, you must follow that. And if the governor says, I'm following it, the only line of attack is because a disqualification petition is pending.
What is the objective material for the governor in this case?
The objective material was the moment, firstly, 7 independent MLAs, the leader of the opposition, and 34 out of the 55 MLAs say you do not...
Independent MLAs have nothing to do with the strength of the government in the House.
Yes, they do. They were part of the government.
There is absolutely no role because that applied when the government was formed.
No, my lords. They continued to support the government. Those 7 were part of they withdrew support to the government, my lords. Those 7 withdrew support to the government.
Were they holding ministerial posts?
I don't. Were they holding ministerial posts?
2 of them.
2 of them. My lords, they were part of the government. They were part of. Let's test it. When your lordships in para 121 of Bomai say that the governor
remaining gave letters of support to the government during its formation.
Please, my lords.
The remaining, apart from the 2 who became ministers, did they just check it up later?
There was
Just check it out. Check it out.
Actually, we'll check it out. My lords, please see. MLAs who are part of the government say we are withdrawing support. The leader of the opposition says he has lost support. 34 of the 55 ruling party MLAs say that we represent the real Shiv Sena. We have no faith in this coalition continuing. What is wrong? Have called for a floor test. If he had dissolved the house, if he had called someone else to form the government, dismissed the government, he's not done any of it. He's just said you come and prove your majority on the floor of the house. Their entire argument is that because a disqualification is pending, test that proposition, my lords. According to us, because we passed a resolution, they gave a disqualification notice to us. That's our case. Reverse the proposition. Suppose you want to defeat any bill, any decision on the floor of the house, the easiest thing is give disqualification notices to parties.
Now, in this context, if you see para 75 of Shivraj Singh, why the court there held that there was objective material before the governor. That's the kind of, just see that para 75 and 76 in the press case. So we then get some flavor of what are the circumstances in which the governor can call for a protest. Just see that para 75.
Yes, my lord. May I have your lordship's permission, Harry? In the present case, the facts which have come on record indicate that the budget session of the Legislative Assembly had been convened on the aid and advice of the Council of Ministers to commence on from 16/3/2020. The governor was intimated that 22 members owing allegiance to the INC has tendered their resignation to the Speaker of the Assembly. Copies of the resignation letters were forwarded to the governor. At this stage, the validity of these resignations had not been discerned and no decision had been made by the Speaker as to whether the resignations were voluntary or genuine. The Chief Minister subsequently tendered the advice to the governor for the removal of the 6 ministers who were ministers in the state government. On 13/3/2020, the Speaker of the Legislative Assembly issued notices of disqualification. However, on 14/3/2020, resignations of 6 members who were ministers of incumbent government were accepted by the Speaker, acting in exercise of the constitutional authority under the proviso to Article 193B. The Chief Minister, adverting to the turmoil in the state, addressed a communication to the Governor, 13/3/20, stating that the convening of the floor test would be a sure basis for resolving the conundrum. This is a strong indication that the Chief Minister himself was of the opinion that the situation in the state had cast his government's majority in doubt. However, upon the convening of the Legislative Assembly, no floor test was conducted and the House was adjourned till 26/3/2020. These facts form the basis on which the governor advised that a floor test be conducted. Based on the resignation of the 6 ministers of the incumbent government accepted by the Speaker, the purported resignation of 16 more members belonging to the INC, and the refusal of the Chief Minister to conduct a floor test despite the House having been convened on 16/3/2020, the exercise of power by the governor to convene the floor test cannot be regarded as constitutionally improper. Now, my lords, apply to the facts of our case. The governor notes there is violence, they are being attacked. 34 of 55 do not support the ministry. 7 supporting independents have also withdrawn. The leader of the opposition has also written to the same extent. He doesn't dissolve. He doesn't swear in another government in power. He says you come and prove your majority. And your lordships, if have right through said that it's his duty to summon the House and said that no governor or any other individual should form an independent opinion. Manoj and Bomai, your lordships, has said that the moment a governor starts forming in these matters and substituting his opinion to dissolve the House, instead of a floor test being ordered, it would be dangerous for democracy. I'm just testing the proposition of the other side, my lord, because it is being said or not. This material, in my respectful submission, is more than sufficient to meet the test of judicial review, because your lordships are not substituting your view for that of the governor. All that your lordships are seeing is whether the decision-making process was apt, it was not accentuated by malafide or bias in this matter, or any extraneous consideration was not taken into account. And in the given circumstances, my lords, the governor, taking the requisite facts into account, the surrounding circumstances into account, comes to an informed decision that floor test should be conducted. And he orders a floor test. Now, because you feel the floor test would have led to a situation where you were unable to face the majority, then that should be the end of your government. Which government should be allowed to continue which cannot face a floor test, my lords? Irrespective of disqualifications pending or not pending, can any elected representative ever say that I want to continue in the ministry as an elected government without facing a floor test?
Now just look at the governor's letter. Can this even, can this be suitable? I mean, look at para 1 and para 2. What does he say? That convenience compilation number,
Nothing.
that convenience compilation number 2.
Volume 2.
PDF 3 to
Page 326.
Yes, pura.
Just let's read that.
Yes, my lord, I'll read the whole thing. I'll read the whole letter.
Dear Shri Uddhavji.
Yes. I'm in receipt of 2 letters dated 28/6/2022, which have been received at the Raj Bhavan, Mumbai. The first letter has been given by 7 independent MLAs stating that you have lost the majority on the floor of the Vidhan Sabha and requesting me to call for a special session of the Maharashtra Legislative Assembly and to direct you to prove your majority on the floor of the House. A similar letter dated so-and-so has been received from the leader of the opposition stating that you have lost the majority in the Maharashtra Legislative Assembly and a floor test for proving your majority in the Vidhan Sabha is urgently required. I'm in receipt of a resolution dated 21/6/2022 signed by 34 members of Shiv Sena Legislative Party stating that there is enormous discontent within the Shiv Sena cadre and the electorate on account of the alliance of the NCP and INC. The resolution clearly indicates that the majority members of Shiv Sena Legislature Party want to exit the alliance with NCP and INC, and to that end, they have reaffirmed the appointment of the leader of the Shiv Sena Legislature Party. I am also in receipt of a letter dated 21/6/2022 addressed by Eknath Rao Shinde to the Deputy Speaker stating that the purported appointment of one Mr. Ajay Chaudhary is illegal, having been made by 16 MLAs without notice and without quorum, and therefore the same is inoperative. A letter dated 25/6/2022 was also received by me, whereby 38 members of the Shiv Sena Legislature Party have alleged that the security provided by the state government to them and their family members have been illegally withdrawn. It is stated in the letter that various leaders of the state government are instigating the cadre to initiate violence against 38 MLAs, as a result of which the offices of some of these MLAs are vandalized. I have also been made aware that there have been grave threat to life of these 38 members and also their families. I have seen the developments through electronic and print media very closely, which substantiate the above facts. The apprehension of the MLAs is also fortified by the letter of the leader of the opposition, who has in fact provided links to videos where Mr. Sanjay Raut has openly stated that dead bodies of the MLAs will come to Mumbai and will be sent for post-mortem. Mr. Sanjay Raut in an interview given to the national TV has also said that ongoing violence is not even a trailer but is just the warming up. Certain news articles reporting open and rather disturbing threats to 39 MLAs of Shiv Sena have also been enclosed with the letter issued by the leader of the opposition. In response to the aforesaid letter dated 25/6/2022 received by me on behalf of MLAs of the Shiv Sena, I had via communication dated 25/6/22 directed 1. The Home Secretary, Ministry of Home Affairs, Government of India; 2. The Chief Secretary to the Government of Maharashtra; and 3. The Additional Chief Secretary, Home Department, Government of Maharashtra, Director General of Police, Maharashtra State, and the Commissioner of Police, Mumbai, to provide adequate police protection to the MLAs and their families on the immediate basis. It is thus clear that a majority of Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena Legislature Party that they intend to exit from the Maharashtra Vikas Agadi government, and that you have been made aware of the same and that you are trying to win over your MLAs and cadre by means which are not democratic. I am therefore confident that you and your government had lost the trust of the House and the government is in minority. The Honorable Supreme Court of India, in a range of decisions, has time and again held that the governor possesses a power to monitor that the elected government continues to enjoy the confidence of the Legislative Assembly. It is therefore within my power and discretion to call for special session of the Maharashtra Legislative Assembly and direct a floor test to ascertain as to whether you enjoy the confidence of the majority in the House. My discretion is guided by the aforesaid facts. Please refer to Shivraj Singh Chauhan versus Speaker, Madhya Pradesh Legislative Assembly. Further, with a view to obviate any undemocratic method being employed, such as violence, illegitimate and unseemly political bargaining and horse trading in a quest for political power, the Honorable Supreme Court of India has consistently insisted upon convening a trust vote at the earliest date. In the aforesaid case of Shivraj Singh Chauhan, the Honorable Supreme Court has held that a trust vote in the ultimate analysis is to uphold the political accountability of the elected government. Some of the other judgments of the Honorable Supreme Court of India, which require the immediate holding of the poll test, are so and so. As per the judgment of Shivraj Singh Chauhan, where the circumstances of violence and coercion exist that would undermine a free and fair vote in the Assembly, the governor must take measures to ensure that the sanctity of the trust vote is maintained. In the present case, use of undemocratic means, such as violence and coercion, to influence the vote cannot be ruled out. The Maharashtra Legislative Assembly rules contemplate voting by a division by asking members to rise in their seats for the purpose of counting the votes. Such procedure for voting would, according to me, ensure that the members are allowed a free and fair vote in the present case. This is in line with the series of judgments delivered by the Honorable Supreme Court. Therefore, in keeping with the constitutional and democratic values and principles, as also the law laid down by Honorable Supreme Court of India and in pursuance of the powers conferred by Article 174, read with 175(2) of the Constitution, I hereby issue the following direction. A special session of the Maharashtra Vidhan Sabha be summoned on 30th/6/2022 at 11 a.m. with the only agenda of a trust vote against the government. The business of the House shall be conducted in such a way that the speeches, if any, are concluded in a short period of time, and the trust vote is concluded on 30th/6 by 5 p.m. The voting will be conducted by members to rise in their seats for the purpose of...
The only reason really, a lot of this is completely constitutionally extraneous. The fact that, some MLAs have said that, well, their safety is in peril, that I directed as a governor that their safety should be provided. This has nothing to do on whether the government should be asked to face a trust vote. The only point which he says really is these 2 points. One, 7 MLAs have said that they don't owe allegiance to the government, and more important, the 34 MLAs have indicated that they want Shiv Sena to exit from the alliance
Yes.
with INC and the Maharashtra Vikas Sabha.
And not from the party, but from the coalition government. Manos, the resolution of 21/6/2022, as also this letter categorically says that there is a huge discontent within the party.
All what happens is that, once governors start this process of, intervening in a sitting house, that only sort of gives...
Manos, may I with respect say, when you...
Why not ask whoever wants to move a no confidence motion?
Manos, may I with respect, my lords, your lordships have said...
Why should a government which has been formed and in respect of which there was absolutely no disquiet just a month earlier, he asked to suddenly face a trust vote?
Manos, may I with respect say...
On the basis of these...
Manos, for a government to lose a majority, there cannot be a cutoff date. That event in politics can occur at any time. Whether it enjoyed majority a month earlier or it loses majority a month later, with utmost humility I submit, is inconsequential. What is important is on the date when the governor applies his mind, was there a representation by the requisite number of members of the Legislative Assembly to say that we no longer have any faith in this government? Consciously on 21st of June 2022, 34 or 35 MLAs wrote to show that there is a huge discontent and discord within the party of an MVA alliance continuing. They don't say we are merging with someone else or we are splitting. They say within the party, and we do not want this government to continue. 7 independent MLAs who are part of the government, right? Now, my lords, I put a question to myself when from 9 judges to Shivraj Chauhan, your lordships has said the first duty is to summon the House. Why should that governor ask anyone to move a vote of no confidence? When your lordships have guided the governor time and again in various situations to say that the first right you must exercise as a constitutional authority is to summon the House and call for a floor test and ask the Chief Minister to prove his majority. Why should that governor exercise in discretion and say that no, because 1 month earlier there was no disquiet, today a vote of no confidence should be moved and not a floor test? And ultimately, as I respectfully submitted, your lordships are not sitting as a court of appeal. Even if your lordships feel that another course of action may have been a more appropriate course of action, the fact is, as long as what the governor does is within the constitutional principles as laid down in Gowai and Shivraj Singh Chauhan, that is good enough. Now, for a minute, leave this aside, what fell from my lords, the violence, what was happening to MLAs, exclude that. What is required is the essential ingredient for a floor test. The need for a floor test arises when there is a representation that the concerned chief minister or government has lost the confidence of the House. Now, as far as the confidence of the House is concerned, what material will the government look at? The governor look at? The governor will naturally look at the representations of various MLAs in the assembly to say that they are no longer supporting. What other material can he look at? And that is why, my lords, your lordships.
The head of the political party had not informed the governor that we are withdrawing from the alliance.
No, my lords.
The alliance still continued between the 3 parties. There was no intimation by the head of the political party.
Who was also the chief minister.
He had not intimated the government.
He had not
We are
intimated.
withdrawing from this alliance.
My lords, he need not. But if 34 out of 55 write to him to say, Manas, again, as I'm saying, he's not dealing with 10th schedule. That's a separate argument I'll come to. He is dealing with 34 out of the 55 MLAs writing to him to say, we have no faith in this government, in this chief minister. 7 independent MLAs who are part of the government say, we have no faith in this government. Leave aside the leader of the opposition for a minute. Now, my lords, when a governor takes a decision to conduct a floor test, what is the most important consideration in his mind? The most important consideration in his
Mr. Call, read para 78 of the judgment.
My lords, of
Shivraj Singh Chauhan.
just give me a moment.
Apropos what you are saying.
78. The idea underlying the trust, my lord, the Chief Justice has that.
Yeah.
The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. Assertion of accountability is a mirror image of the collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shone a light on the often fluid allegiances of democratically elected representatives. This is a matter for their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time of the trust vote is directed. All political parties are equally at risk of losing the support of their elected legislators, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both the sides of the disputes congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist, that would undermine a free and fair vote in the assembly. The governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In the circumstances as they have emerged in the case, the exercise of authority by the governor who was based on circumstances which were legitimate to the purpose of ensuring that the norm of collective responsibility is duly preserved, there existed no extraordinary circumstance for the governor to determine that a trust vote was not appropriate course of action on 16/3/2020. Now, my lords, all that I am respectfully submitting today is that merely because it will turn in favor of one or the other, your lordships deal with those issues. I put myself in the governor's position. My lord, suppose he had not held a trust vote. One of the first challenges would have been, despite a 9-judges bench, despite Shivraj Singh Chauhan, despite MLAs writing to him, why did he not hold the floor test? Where is the requirement in law, my lord, that if a governor, after due application of mind, comes to a conclusion that a trust vote ought to be held, he should nonetheless have a vote of confidence moved on the floor of the House and not go in for a floor test? Where is that requirement in law? And presuming for a minute both options are available and he opts for one instead of the other, would that be enough for your lordships, an exercise of your lordships' extraordinary jurisdiction to strike down the decision of the governor in a matter like this? That this is a decision so influenced by extraneous consideration or so biased or unfair, accentuated by malafide, that we will strike it down as a decision. It's a decision based on due representations made by MLAs.
Yes.
And naturally, my lord, when these MLAs make representations, these are on political considerations.
Mr. Kaul, as your claim is not either a split or a merger, your
Yes.
claim is on the ground that you are the political party.
Right.
Now, in the information given to the governor, to what extent the information available as to you have garnered the political
Yes. So, my lord,
majority, political, not the legislative majority.
my lord,
Where is that kind of a material?
I'll just come to it, my lords.
Yes.
I'll come to
Okay,
it
take your own
tomorrow if your lordships permit.
I'm
Because
just
I'm very grateful. I'm very grateful that your
That's
lordships have
actually,
indicated. Yes.
in so far as the governor's decision is concerned, go by Bommai. The principle of the judicial review is confined to the question as indicated there. Material is available to him, relevant material. Then judicial review is available. The relevant material available for him to direct a floor test must be in relation to that kind of a decision that you have now garnered the political, not the legislative, but political power with respect to the party.
May I with
That material is available or not?
I'll address your lordships tomorrow on that.
No, in your own time.
10th schedule is where this whole argument of legislature, political party, is political party co-joined with legislature party? Was it only within the political party or within the legislature party is one part. As far as the governor in exercising his powers for a floor test is concerned, his only consideration is whether on the floor of the House, the members enjoy the requisite majority or not. And my respectful submission there to your lordships would be that there all that he has to see is that the elected representatives who constitute the total composition of the House, is there a substantial challenge to say that a large number of them are withdrawing their support to the ministry, which raises a genuine doubt in his mind to say that the majority of the ministry must be proved on the floor of the House, and which material was here. He doesn't have to embark on that exercise, which is a part of 10 schedule, political party, legislature party. All that he has to see is elected representatives, 34 of 55, 7 independent who were supporting, and as I said, exclude the leader of the opposition completely.
But Mr. Kaul, once the government is formed,
Yes.
it is not open to any group of members of parliament or of the legislative assembly to say that, look, we don't want to go with this alliance. You have an alliance of 5 parties. It is not open to, say, a group of persons who owe allegiance to the dominant political party in the alliance, as in this case, the Shiv Sena was, right? Shiv Sena had 55 as opposed to 44 of the Congress and 53 of the NCP. It's not open to any one segment of the any political party, whether it was the Shiv Sena or the NCP or the Congress, to say, we don't want to go along with this. That will ipso facto attract the disqualification provisions. You are bound by the whip, and you are bound to vote with your party so long as you are a legislator, unless there is a merger.
That's why, my lords, as I say,
On the one hand, none of them, either 15 or 20 or 25 or 30, can say to the governor that, look, we don't want to go along with the alliance. Answer is very simple. You don't want to go along with the alliance? Vote your leader out in the political party or take a decision in the political party outside. So long as you are a member of the House, you are bound by the discipline of the House. You have to vote with your political party.
So just to answer what my lord,
What they were essentially telling the governor was this: we don't want our political party to continue with this 3-party alliance of the MVA, right? We want to exit from that. Governor takes cognizance of it. Now, what he is essentially taking cognizance of is that there is a breakaway segment of this particular party. In that letter of the governor, one thing which is completely absent is your argument that we are the Shiv Sena. The entire letter is postulated on the fact that there was, out of 55, there are 34 people who want to break away from this alliance. And what is this but not a split?
well, may I have respect say?
The governor at least was not alive to this argument at all, that you represented the Shiv Sena.
May I
extraneous to the exercise of power.
well, may I with respect say that is not something.
The relevant material.
The material before the
Well, that of course the governor's council will
Shivraj, therefore, we were very careful in that those 2 paragraphs to say 22 members had resigned. They didn't defect. They said we quit the assembly. Out of them, 6 resignations were accepted by the speaker. 22 were in the same batch. The speaker went and accepted 6. He kept quiet over the 16. And Dr. Singhvi's argument was that you are trying to prevent the speaker. The floor test essentially is to buck the speaker's decision. So to which we said that, look, they were all 22 sailing together. Why did the speaker accept only 6 and leave the 16 intact? That is not a case where they split. They said, we leave the House.
Well, as I said, I haven't
the consequences, vacate the House.
I haven't even come to the legislature party versus political party argument, because where my contention will be, A, there are 2 political whips appointed on the same day. As per us, we are following the mandate of the party. My Lord the Chief Justice put a question to say that suddenly you decide to do what you want. That's not our case. On 21st of June 2022, a political whip was appointed. The question is whether my political whip or their political whip is the actual political whip. Because if my political whip is the whip, then I have not disobeyed any order at all. So when my Lord the Chief Justice said that by just saying that you don't agree with the government, you ex facie, we've not done that. Our whip, and that is the question when this argument was raised on that day before your lordship, the lordship said, is this the rival faction? whose whip was appointed, that's first for the EC to say which was the party, which was the faction, which was the recognized political party within. Because according to us, the faction within the party, which is the recognized faction today, was the faction which represents the political party and had appointed duly the whip. And the whip argument, when I come to, I'll show to your lordship, right through the convention of the Shiv Sena has been that the legislative party with the requisite authority of the political party appoints the whip, communicates it to the speaker. And even when the 10th schedule existed, when para 3 existed, your lordship said that the limited jurisdiction under 10th schedule of the speaker is to only see a prima facie split in the party, not embark on an independent inquiry. As far as the political party is concerned, that's the domain of the election commission. Today, it is being presumed as if I did not have the requisite political whip in my favor, that I did not represent the requisite majority within the party, and thus I have incurred. I've incurred the disqualification under the Act, under the Constitution. And my respectful submission right through has been, says who? Just because you say doesn't mean I'm disqualified. That has to be decided by an appropriate constitutional authority, which in this case, the wrong has decided in my favor in this matter. But be that as it may, you can't presume and say that you have incurred ex facie the disqualification and thus you were not entitled to right. After all, the concerned body has to decide that. According to me, I represent within it the view of the political party. Our resolution also, my lords, when your lordships put a question to me to say that this part that we are the Shiv Sena was not something which gets reflected in the speaker's letter. My lords, that letter, so I'm so sorry. The governor's letter. That very letter of the governor refers to the resolution of 21st June 2022, which I'll read out tomorrow to your lordships, which says there's an overwhelming discontent in the cadres of the party. The party does not want to continue. So it's not as if the governor just dealt with, and this is my argument which I've just presented before your lordships, the governor was cognizant of the fact that the resolution on the basis of which 34 MLAs wrote to him in turn referred to the large discord and discontent within the political party, which was because of continuing with MVA. The cause is not important. The reason is not important. The reason could be anything. There it was corruption and it was MVA. Could be anything. The fact remains is they were discontent. The fact remains is that an overwhelming part of the political party did not want to go along. Now, whether your whip represents the right wing, then my learned friend started going into when was the committee meeting held, what was, those are not that is not within the purview of the Constitution bench today. That will be decided and is being decided by the EC. That who represents within the party the actual recognized political party. I'll even touch on those 18.7, 27.7, which are not the subject matter of this reference to your lordships.
We'll continue. We'll see the resolution which you said you want.
Yes, I will read, my lords. I'm very, very grateful, my lords. I'll continue to read.
We'll continue tomorrow morning.